Well, good afternoon, everybody. Thank you all so much for being here for the Young Lawyer Chapter panel. This is the new strategic litigation ecosystem. My name is Eli Nachmani. I am the president of the DC Young Lawyer Chapter. I have the honor of introducing this panel today. So strategic litigation vehicles have changed the legal landscape. This has been driven by both for-profit and nonprofit enterprises, along, of course, with the government. And we're delighted today to hear from practitioners across the segments of this ecosystem, including some dear friends who are real rising stars. I'm going to introduce our moderator, who's then going to get us underway. So our moderator today is O.H. Skinner, who is the executive director of the Alliance for Consumers and the president of American JurisLink. O.H. spent almost 5 years serving Arizona Attorney General Mark Brnovich in senior positions, including as Arizona's Solicitor General, where he argued at the Supreme Court of the United States on behalf of Arizona. O.H. is a graduate of the University of Pennsylvania and Harvard Law School. Prior to joining the Arizona Attorney General's office, O.H. practiced at WilmerHale and Ropes & Gray in Boston, and he clerked for the Honorable J.L. Edmondson of the United States Court of Appeals for the 11th Circuit. In 2023, O.H. was a Wasserstein Public Interest Fellow at Harvard Law School, where he counsels students as a Harvard-identified outstanding public interest attorney. O.H., the floor is yours.
Thank you. I struggle with doing long introductions because of the internet, and you guys can look up everyone who's up here, and there's information on their bios. But I will just note that each of the people up here is a fantastic iteration of the current movement landscape, and they do things that are very different than what is just at a traditional big law experience. And I think perhaps maybe I was chosen to moderate this panel because I was once a young lawyer, but also because I was right at that cusp of an era where the transition from everyone left law school, went to a very large law firm, lived the, Megadeth law firm lifestyle, and then eventually spun off into a mid-sized law firm or something else. But they were all versions of the same litigation landscape if you were a litigator. And maybe if you were lucky, you saved up enough money and you would go work for a nonprofit of some type. That seems to be fundamentally changing, right? When I was in the state AG's office, the nature of what students wanted to do seemed to change dramatically. The nature of the young lawyers that we were hiring was changing dramatically. The goals of the lawyers on my team, who are the deputies and assistant SGs, changed dramatically. What they wanted to exit to was a vastly different universe. And there was a massively more robust ecosystem of choices for them. And each of those outfits was getting more sophisticated in how they operate. And I think that so I watched a lot of this happen. And so without going into lengthy introductions, I'll just ask people to go down, starting with my friend Lou, who is the, I think I can safely say, brand new Solicitor General for the state of Missouri. Lou, could you talk a little bit about, I asked each of the panelists here to talk a bit about what it is that their role serves within the movement, why it's attractive to them, and what makes their position kind of special. But each of them will take a different riff on this.
Thank you, O.H. It's great to be here. Looking forward to a fun conversation today. I'm going to talk briefly about what I do, why I do it, and how I got here. And if you're interested in doing impact litigation, that last part might be the most interesting to you. At age 31, I am the youngest state Solicitor General in the country, and I have some tips on how I got here and how you can put yourself in a similar position. So question one, what do I do? I am the Solicitor General of Missouri. I oversee a team of 15 super talented lawyers. I see some of them are here today, and they're great public servants. You should definitely meet them. As a team, we are responsible for the positions that Missouri takes in the appellate courts. Sometimes my team personally briefs and argues cases. More often, we simply review and sign off on the work done by other litigation units within the Attorney General's office. My team also handles special litigation in the trial courts. In handling special litigation, we tend to handle soup to nuts the state's higher profile cases. For example, we defend state laws. including right now the new redistricting plan in Missouri. We also file strategic offensive litigation. For example, we are litigating against the Starbucks corporate DEI program right now. If you represent a company and you still have a DEI program on your website, you are in legal jeopardy. We also use consumer protection litigation to get dangerous drugs off our streets, and our office recently obtained a $24 billion judgment against China for COVID-related antitrust injuries. I love my job, and I'm incredibly blessed to be able to litigate cases like this that make a difference for Missourians and all Americans. Question 2, why did I take this job? Believe it or not, I actually hesitated before doing so. I was previously a lawyer at Jones Day, where I had a good experience. I think my experience at Jones Day was atypical for big law, and I want to talk about why. But I enjoyed it there. I liked the money, and I had a good practice. I focused on election law, with the Republican National Committee being my primary client. And really the best thing about it was the in-court experience that I got at Jones Day. I'm going to come back to that in a minute. But on the whole, I left because I thought that this was a job where you could make a difference. You could file cool cases, you could move the ball on the priorities of the conservative legal movement, and that's absolutely right. For the younger attorneys in the room, I can't recommend it strongly enough. If you want to get in-court experience, if you want to learn how to be a real lawyer, and if you want to get up every morning and feel good about what you're doing, being in a state solicitor general office is fantastic. There are lots of openings around the country. There are some fantastic SGs in states that struggle to recruit because they're a little bit more remote, like Montana, for example. It's a great SG up there, Christian Corrigan. Iowa's fantastic. There's a lot of these great offices. You should consider those jobs. Question 3, this is the last one. How did I get here? Why did 2 Missouri attorneys general feel comfortable giving me this role? The answer is that even by age 30, I had substantial in-court experience and had proven that I could successfully lead litigation teams. And if you're interested in doing that type of work, I have a few tips. First, get good mentors who will teach you how to be a real lawyer. Clerking is a great place to start. You learn how to write, you learn the difference between good and bad lawyering. You get good mentors. I'm very grateful to Justice Gorsuch, Judge Wilkinson, and Judge Sirica for being great mentors to me. And when you pick firms to work at, think about this too. You don't really work for a firm, you work for particular people at a firm. And you want to be looking for people that will look out for you and will take care of you. At Jones Day, I'm very grateful, and I really won't ever be able to repay the debt to John Gore, Yakov Roth, Brett Shoemate, Don McGann, and Tracy Lovett. They invested in me, they taught me how to be a lawyer, and they let me get in the courtroom, which segues to my second tip. Get in the courtroom any way you can. This, I think, is the difference between whether you're going to really take off in your legal career or if you're not. The biggest problem with corporate big law is that it is in their financial interest for you to be a cog in a machine. It's a complex, high-billing, expensive machine, and you play a discrete role in that machine. But the problem is when you're a cog in a complicated machine, you're not easily transferable. You don't have that much value outside that machine. But to be a real lawyer, you have to get in the courtroom, you have to do things like depose witnesses, you have to learn how to shape a factual record, you have to learn how to handle witnesses at trial and to present a factual narrative. And of course, you need to learn how to argue appellate cases too. And at Jones Day, again, it was an atypical experience. My primary mentor there, John Gore, a great election lawyer, let me do that. At age 28, I first chaired a 6-week federal bench trial for the Republican National Committee in San Antonio. And I cross-examined witnesses, I gave directed verdict and closing argument, and then after that, I did a lot of the work on the appeals too with the arguments, and that really was a formative experience. And that put me in a position where, you do know how to be a real lawyer once you've done it. And once you've argued in court, once you've gotten a little bit of experience, it starts to snowball. And so when I interviewed then to be Solicitor General at age 30, I had tried cases. I'd argued cases. I could credibly claim that I knew how to lead litigation teams. And that can't happen unless you get in the courtroom. And so when you're negotiating with employers before signing on the dotted line, demand that. And of course, you can also look for jobs like state SG offices, like at some of the boutique firms or the public interest firms, where they will give you those opportunities. Last point, last tip, stay abreast of intellectual trends. Go to FedSoc, listen to the Supreme Court arguments, read the opinions. For myself, I had taught administrative law at Penn Law School. I'd written some articles. I try to stay, in touch with the trends. And that's going to make you a better lawyer. That's going to allow you to shape impact litigation. Small example is I helped persuade some judges to adopt novel theories of standing to limit election law claims. That wouldn't be possible if I hadn't paid really close attention to the Supreme Court's recent standing jurisprudence. If you do that, you will have ideas and inspiration for how to actually move the ball on the ground when litigating cases. So, in summary, work in state AG offices, but no matter what you do, get good mentors, get in court, and stay attuned to current intellectual trends. Thank you.
I think Lou's going to get bonus points for warning me that he was going to go very long and then not going long, so good job. So Cody, you're at a very well thought of associate at perhaps one of the firms that I love the most in this world, even though I've never worked there, which is at Consovoy. Can you talk about, that is a firm that it's not just hiring people out of big law, right? So can you talk about your experience with all the things that, in the framing of how Lou was speaking?
Yes, thank you, OH. And first of all, thank you to the Federalist Society for the opportunity to speak today. I'm excited to be here and to talk a little bit about strategic litigation from the for-profit boutique firm perspective. And since Lou did not capitalize on his time, I might take a little bit of the rest of that, but I'll try to be quick. At the outset, I'll add the customary disclaimer that anything I say is my view alone. It's not the view of my firm. That said, while I'm not speaking for my firm, I'm going to be speaking a lot about it. As OH mentioned, I am an associate at Consovoy McCarthy, PLLC, which is a small firm of about 30 attorneys that specializes in complex administrative and constitutional litigation. If you were here at the first panel yesterday, you got to hear Kim Norris talk about one of the seminal cases that started the firm, which is Students for Fair Admissions versus Harvard. And at the outset, yes, let me say a few words about how a boutique operates conceptually and how I ended up in this particular career. The basic idea behind the boutique model is this: traditional law firms, aka big law, are premised on the idea that most matters require armies of lawyers in order to represent the client effectively, what Lou was referring to as placing younger lawyers in a cog in the wheel. And to be sure, this approach remains very useful in certain cases, particularly cases that have oceans of evidence that needs to be combed through. But from a client perspective, this approach also imposes massive costs to maintain that type of overhead and operating structure, and to some extent it makes the entire firm less efficient and less able to truly offer nimble and innovative services, including by way of how the litigation is funded. Now, from the attorney's perspective, that big law approach often buries talented lawyers behind multiple waves of supervisors, and therefore receive fewer opportunities to directly practice. So boutique firms, like my firm, Consovoy McCarthy, are, I think, currently on the rise across the nation because many cases, many very important cases, do not require that army of lawyers combing through endless evidentiary production. We find that a lot of these very important cases are instead won on the strength of the legal pleadings and the quality of the advocacy without the army behind it. And so the boutique model is, and what my firm is built around, is the idea of taking a small group of talented attorneys with niche experience in specialized area. For us, it's largely appellate litigation, and for other firms, it could be trial, it could be administrative proceeding, and so on. And providing that at a fraction of the cost that is charged by the big firms, because we can operate efficiently, and we can operate with a very lean team of talented attorneys. And so it's a win for us, it's a win for the clients, and it allows us to pick and choose and represent the issues that we care very deeply about, and represent the clients and the kinds of causes that oftentimes big law won't directly take, and even sometimes won't allow its attorneys to take on in pro bono litigation. Now quickly, I'll pivot a little bit and add a word on why I chose to come to Consovoy when I was coming off of my clerkships. And I very strongly encourage any attorney in the room to, if you don't go to a Solicitor General's office, to consider practicing at one of the many boutiques that are popping up across the nation. Consovoy McCarthy was a very easy choice for me because it offered a combination that traditional firms largely could not match, which was mission, responsibility, and impact. Look, I think the basic idea is that it's not enough for us to admire conservative principles from a distance. I think that we have an obligation, those of us who care about these things, to put our hands to the work, to fight for the limited government, to fight for rule of law, to fight back against government overreach and bad actors. And as I'm sure you all know, as the first President Roosevelt said, the credit goes to the man in the arena. Now, I love this week. I love NLC and the fact that we all get to come together and talk about these interesting topics. And at the same time, this week should not be the only week of the year that you're thinking about these topics. And at Consovoy McCarthy, much like the Solicitor General units around the nation, every day we get to work on these topics. Every day we work on free speech, the Second Amendment. At Consovoy, we do a lot of work about stopping systemic institutional racism in institutions across the country. We do work supporting states' pro-life laws, stopping schools from conducting gender transitioning behind parents' backs. Those causes are out there, and those causes need good attorneys. And with the boutique model, with our model, and being small and flexible and efficient, we get to serve those causes every day in a way that furthers strategic cause-based litigation and allows us to be affordable to the client and not operate in the red. So that's the mission, that's the biggest part. And the icing on the cake on top of that is the responsibility and the impact that we get to have. I think when you go to a boutique law firm, regardless of what that firm specializes in, you're going to receive exponentially more hands-on experience and direct responsibility than you will normally receive at a traditional firm, even though Lou's experience may have been a little bit different. I remember some of my former co-clerks being particularly excited, the ones who did go to traditional law firms, when in month 4 or 5 of their first year at the law firm, they got to draft a section of a reply brief. And then another one got to write a section of an amicus brief. And it's very, very different in a boutique law firm. In my first few months, thanks to the trust of some truly incredible partners who I get to work for, I was able to draft multiple complaints. I was doing multiple dispositive motions, multiple state and federal appellate court cases, and just in the last few months of my first year at the firm, a couple cases that were on the Supreme Court's merit docket this term. Now, that is a lot of responsibility to live up to in just a first year of practice. There's not a lot of training. There's not a lot of training wheels going on. But it's opportunities that, by and large, for young attorneys, you're not going to get at a traditional law firm. And so you should probably consider a boutique. Now, of course, the topic of this panel is about the emerging strategic litigation. I haven't discussed any specifics yet, so let me just spend just a minute on that. And as I was thinking about this, there is some incredibly exciting, truly groundbreaking strategic litigation that Consovoy McCarthy is currently involved in, and I cannot tell you anything about any of that. I'm very sorry. If you want to know more about that, you should find one of our amazing partners and ask them for a job, or just watch your legal news headlines sometime in the next 6 to 12 months. Maybe you'll see something. I will briefly mention the existing categories of strategic litigation that we work in. So the 3 main buckets I'll mention now. We do, in fact, do a lot of work for states. We also, in fact, do a lot of work for nonprofits. And then we also do something that looks a little bit more like traditional commercial litigation, but which we select because of a particular nexus to a cause that we care about. So the first, you've heard from Lou, and you're going to hear from my friend Jason about the fun work that Solicitor General offices do. Boutiques can do the same, and in fact, we do. At Consovoy McCarthy, we do a great deal of work for both states and state SGs. For example, just a few weeks ago, the Supreme Court heard oral arguments on a case called Case versus Montana, a Fourth Amendment case about exigent circumstances. And Lou's friend Christian, a good friend of the firm, had hired Constable McCarthy to help write the briefs and help prepare him for that argument. A similar thing took place last term. Constable McCarthy was hired by the state of Tennessee to help with United States versus Scrimeti. Right now, we are currently representing the state of Alaska in a petition for cert in a very important case on a conflict between federal and state regulations of navigable waterways. And we do much, much, much more of that. It's a very large portion of our docket. And so a lot of people have said, and I think it might be fair to say, that if you come to a boutique, if you come to Constable McCarthy, you get to do Solicitor General type work and not with the Solicitor General type salary, which is kind of a fun thing. The second big bucket of our strategic litigation is also our work for nonprofits, and that may be the area that you've heard a little bit more about Constable McCarthy. Obviously, we do a lot of work for Students for Fair Admissions, both the seminal Harvard case and the continuing follow-on cases where we're still going after, institutions that continue to be systemically racist. We also do work in similar veins for the American Alliance of Equal Rights. We do work for Do No Harm, and we also do work for generalist isn't quite the right word, but for other types of nonprofits such as American First Legal and others. This is also a very extremely large part of our docket because since we can offer our services efficiently and at such competitive rates, oftentimes it makes more sense for the nonprofits who want to conduct regular cause-based litigation to hire us rather than standing up a full-time litigation team on their own. And even for those nonprofits that do have their own litigation teams, sometimes it makes sense for us to bring us in for our specialized knowledge on a particular matter. And when we represent nonprofits in that way, strategically, it often functions as a partnership. So sometimes we find the ideal client, or they find the ideal client and bring it to us. Sometimes we find a client on a particular mission who needs to be connected with the right nonprofit, and we take it for them. So it's a very symbiotic relationship. And then the third bucket I'll just mention briefly is Constable McCarthy is able to take on work on a variety of matters that, like I said, looks closer to the traditional commercial litigation, but which we specifically choose for having a specific nexus to an important cause. So one example of this that you may have heard of is actually Corner Post versus Board of Governors of the Federal Reserve, which went up to the Supreme Court on a procedural matter. We're back down on the merits, so I won't go too much into that. On its face, it's a case about debit card transaction fees. Not the most exciting thing. But the nexus is that we think, we look at this and we think we get to represent a small business against clear bureaucratic overreach, and we get to argue against what we see as a government agency misreading Congress's explicit statutory directive and manipulating the economy. We tend to think that that's kind of an important thing. And so while it's a commercial activity, we find a cause that we like, and that's why we choose that. Another great example you may have heard of is Constavoy's mass arbitration against Uber Eats. Again, it sounds a little bit more just like a normal commercial thing that the traditional firm would do and get involved in. But the nexus why we went after Uber Eats is, or why we chose to represent Uber Eats is that Uber Eats had implemented an explicit policy of racial discrimination among its drivers. And so, again, a little more commercial, but we find an important cause and we want to represent that. So that's an overview of the existing buckets of strategic litigation that Constable McCarthy is involved in. And the thread that I think runs through all of that is that by operating on a carefully constructed model of high efficiency and top-tier representation, we are able to work for not only all of these guys, but we are able to work on very important cases, very important causes that have real impact on society. And we're able to do it in a way that financially makes sense for the clients and financially makes sense for us. So I'll wrap it up there, and maybe we get some more details in the Q&A.
So, Amanda, Jason. Jason, you, I think, are one of these people who came from Big Law to the SG role. You're the Chief Deputy Solicitor General in Florida, but we both know that functionally you're doing a lot of the day-to-day job, given that the people carrying the Solicitor General title also carry other titles in your office. So can you lay out how you ended up where you are and your experience coming from Gibson Dunn, which is, kind of the exact opposite of what Cody just described?
Right. Well, thank you, OH, and it's great to be here. It's a real privilege, so thank you to the Federalist Society, and especially getting to be on a panel with friends. So, thank you. My story, Lou's already explained a lot of what state SG's offices do, so I'll add a little bit of that, but I just want to explain how I thought about ending up where I am. And the way I would describe it is a very clear top-line interest of, I always wanted to be in the public policy and legal fight I imagine for the many of you who are willing to travel to DC for NLC, you probably share a similar conviction. But for me, from the beginning, it had always been, what interests, what passions, what limited intellect has the Lord given me, and it always centered on the idea of fighting for life, fighting for family, fighting for marriage, and human flourishing. And so always knew I wanted to do that, and started with a clerkship with a very conservative judge, Lawrence Van Dyke on the Ninth Circuit. Taught me a lot about...
He's sitting back there, so good job.
Oh, okay. Well, good, because I was about to say something nice.
Just figured I would just protect you there.
Judge Van Dyke, a model of courage under fire. And so you see from your first start of what it looks like to really stand up for what you believe in, even when it comes with a cost. And so had seen that and was starting to think about next steps. Thought a lot about Consovoy, where I was a summer intern, my 1L year, and love the firm. But ended up deciding to go big law. Part of it was financial. Part of it, honestly, in hindsight, might have just been the pressure of that's what everyone does, and it can feel very intimidating to try to break off early and do something that's not the safe and standard path. So I ended up going to Gibson Dunn, was there for 2 years in Dallas, and similar to Lou, I had some incredible mentors. I had some incredible friends at Gibson. There are some conservative appellate lawyers who are phenomenal there, many of whom are here. So not to bash the particulars, but I really struggled. Gibson kind of killed me after 2.5 years. I am not one of those abstract legal minds that care so much about this random procedural question in random state court. Corporation 1 trading $1 million with Corporation 2 just doesn't do it for me. And so that on top of the hours, the grind, the pressure, I confirmed, for 2.5 years that was not what I wanted to do. But my time, continued to learn, continued to develop as a lawyer. But the whole time I was there, I had a sticky note on my laptop. And it's a C.S. Lewis quote that, again, thinking about these things was always very helpful for me. And it's, "Happy work is best done by the man who holds his long-term plans loosely and works day unto day for the Lord." So the idea of just being excellent where you are, making sure that the people you work for think highly of you, that you're honoring them, honoring the client, even in the cases that are hard to litigate day in, day out, because there's not why I went to law school, why I entered the legal profession. But just being a reminder of doing that well and letting things play out how they will. And that happened when, for me, the start was President Trump wins, excited, let's take back the country, let's ride. And so I start looking into the administration, but I call a friend and mentor who is in the Florida Attorney General's office to get his take. And he says, forget all of that. The Chief Deputy SG spot is opening up. I had no idea. But it was also to Tallahassee, Florida. I had never been to Tallahassee, Florida. The first time I was there was with the U-Haul. And so, but that said, it was a great opportunity. I knew the great work that state SG offices do. And more importantly, I knew the new Attorney General in Florida, James Uthmeyer, and the leadership there is not messing around, and they are leading on the front of every important issue. So the chance to work for those people and to know you can contribute significantly, it was worth kind of taking the pivot. And the job has been incredible. The day-to-day, Lou's talked a lot, especially about the affirmative litigation, and we do a lot of that. There's also, most of my day is defending laws, Florida laws. One example, there's this small detention facility in the Everglades. It's called Alligator Alcatraz. Well, it turns out liberals don't love it. And so there's about a half dozen lawsuits against the site that our office is defending. And so that keeps us busy. But just pushing on all of these issues has just been a joy, again, invigorated, getting to fight for things that matter instead of, at best, mixed corporation lawsuits, at worst, being on the wrong side of issues has been a real relief, a real joy for me. And then just OH asked about responsibility. Lou mentioned it as being a cog in the wheel. I was, again, appellate associate brief writer number 4. And you would do work, it would get reviewed 6 times, edited 4 times, and then submitted. Now, I'm just making decisions. In multi-state negotiations with huge companies or with the federal government, it's just all of a sudden you're the one making decisions. And it's because these shops need good lawyers who they can trust. And so you go from being a completely replaceable, whoever replaced me at Gibson Dunn they were back up to speed in 4 days. Like, now you go from there where you truly are a cog to getting to be in the room where it's happening, your voice is actually being heard, getting to make big decisions. I've had 4 arguments in 6 months at the Florida SG's office. I had, 0 in 2.5 years in big law. And so it really has been an incredible experience, and I can't imagine going back.
So, Amanda, I think one cadence here that you'll notice that is at least very highly relevant from my perspective as a person who's had some of these different jobs is the state cadence is incredibly high. The throughput on the pipe is incredibly high, but you don't get to spend as much time as you might like with every brief or every case. I mean, you're kind of on the other end, which is Beckett is known as a shop that, at least from my perspective in a state, picks cases incredibly wisely, narrates your cases incredibly wisely, and is going to litigate a case for perhaps years before you reach the actual purpose of the case. So can you talk about that experience? Because it is literally the polar opposite of what Jason just described.
Sure. Good. I think this is on. Thanks. So thank you, OH, and thank you to the Federalist Society, both for having this panel, for hosting it this year, and for including me on it. I think this is a panel that would have been very influential for me as a law student and a young attorney who was very interested in public interest work generally, but didn't necessarily know exactly where I fit, or especially how all of all of us at this panel, how we all work together, from government, nonprofit, for-profit. We each play our own role, but we do work together, and I think that this is a really great opportunity to talk about that. And at the same time, if you would have told me 6 years ago that I would be here, be in my dream job, and be speaking at the Federalist Society's National Lawyers Convention, I would have been in complete disbelief. So it's really a privilege to be here. And like Jason said, with friends is really incredible. So I work at the Beckett Fund for Religious Liberty. Beckett is a nonprofit law firm that focuses on defending people of all faiths and defending religious liberty for all. So we say that we litigate on behalf of clients from A to Z, from Anglicans to Zoroastrians. And in some ways, our work is very niche. It's all religious liberty, but it really does span across different subject matter areas. So we have tax cases, we have employment cases, tort cases, and then various different religious liberty issues are coming up all the time. So I have Establishment Clause cases, free exercise, church autonomy, free speech. So it actually is quite varied, while also getting deeper into the weeds than a lot of my colleagues on this panel. They have more of a breadth, and I am starting to get more of a depth at Beckett. So I'll get a little bit into what Beckett does throughout the course of the panel, but I wanted to touch on how I got here. As I said, being at Beckett as counsel was my dream job. So it was a temptation when I was preparing for this panel to just pick out some key resume lines and basically just create a story that seems very linear and obvious, and in some ways maybe it was. There are definitely things I did and I would recommend others do if they do have a specific area they'd like to get into, but I know a lot of it was providential, a lot of it was twists and turns, and so I kind of want to just recognize that before getting into how my path led me here. And I think really what I would say was the baseline for it was finding something that I was passionate about and then taking the next right step. And so for me, my passion for religious liberty started when I was in undergrad, actually. I was a journalism major, so I was studying journalism, took a course on free speech that got me into the First Amendment generally, but I was at a religious undergrad that was undergoing some internal pressure and external pressure. I was at Pepperdine, so in California, and just to give some context, I graduated a month before Obergefell came out. So there was a lot of social pressure at that time on Pepperdine. And I was seeing how the faculty was kind of struggling to respond to that, and how it seemed to be affecting the students. And so both the entity's ability to function as a religious university, but also the students being able to live out their faith as well. So something that felt very close to home for me, something that I was always hoping I would be able to advocate for in some way, but I didn't necessarily know what that looked like. So I went to law school. At that time, the only thing I really knew that I wanted to do was to apply to the Alliance Defending Freedom's Blackstone Fellowship. I'd had several friends and mentors who had done it. I knew they did great work on behalf of religious entities and individuals. And then I also got a chance to meet with Luke Goodrich, one of our VPs at Beckett, one of our most senior attorneys, and got to talk to him about the fantastic work Beckett was doing. And I was just like, that sounds so exciting. Like, how would I get involved in something like that? And he said, well, we have an internship program. If you'd like to come, work with us over the summer, here's how you'd apply. And luckily, I was able to couple Blackstone and Beckett. So I got to work with Beckett and with ADF my first summer, and it really just showed me all of the incredible work I could be doing if I were to do this long term. But even being like a small part of it was so meaningful to me and was something I knew I wanted to find ways to stay involved, even if I was in government or in private practice. So at that point, I went back to law school and tried to take as many courses and be involved in clinics and my journal and just trying to stay abreast of religious liberty issues and stay connected, particularly within the FedSoc community, just getting to hear about what others were doing. And then I think at the time I viewed it as sort of I had a 5 to 7 year plan that was very clear, and then beyond that it was we'll figure it out. So I did a couple clerkships, district and circuit, and then spent 2.5 years at a firm and kind of was hitting a point where I was like, I'm actually enjoying big law more than I thought. I know that I might be an anomaly in that, but I knew that I didn't want to necessarily stay and make partner. I knew that that's not why I went to law school. It's not what had been motivating me. So Beckett had an opening. I had stayed in touch with some of my now colleagues, and I just started talking about, what would it look like to come back? And it all happened actually very quickly and with a lot of peace, which for me has always been a big marker of something that is the next right step. So I joined Beckett as counsel about 1 year and 4 months ago, last summer. And as I said, I'm now litigating a wide variety of cases in state and federal courts, in district court, all the way up to the Supreme Court, and really just enjoying getting deeper into an area of law. It's been great to continue getting breadth in my other, the clerkships and in private practice. But I think that the one thing that nonprofits, especially nonprofits that are working in one specific area, our feature is really the expertise. So we're getting to work with everyone else on this panel, but we're coming in with the expertise and with the focus and with the overall mission of really trying to advance religious liberty for all.
BB, yours is different than some of these here because I think you've transitioned to what is the most interesting part of working for a state as a person who cares a lot about consumer protection. Can you talk about that? Because I also think that your big law experience is exactly the opposite of the two prior private to public transitions. So can you talk about that? Because I think it makes you dramatically better at what you do. And I don't think a lot of people would normally think of that, but I think it's really impactful.
Absolutely. So I was a brand and marketing attorney essentially in San Francisco, big law, loved it, loved the work, loved my clients. I had mentors who invested in me, let me do things, argued with the client to get them to to pay for me to do X, Y, or Z. I got to run collection cases by myself. If you ask for that type of stuff in big law, they will find a way to get it to you. And that really did shape me and propel me and build that skill set that OH is talking about. And then one day I received a call from a law school friend, so stay in touch, all of you. And he asked me if I'd want to move to Nebraska and do consumer protection there. What I was doing in big law is consumer protection, but for companies. I'd enforce their rights, I'd knock out scams, I'd enforce right of publicity, and then I'd do complex commercial litigation. I have lived in LA, New York, and San Francisco. I've never been to Nebraska. My first time there was my job interview, and then I met Attorney General Mike Hilgers, and I realized that he was the type of person I wanted to work for. He had the heart for making this world a better place and doing it through his role at the AG's office. So I took the biggest career risk ever and moved to the middle of the country where I didn't know anyone. And now I run the Consumer Protection Bureau in the Nebraska AG's office. We do everything from antitrust to unfair deceptive trade practices, data privacy, charities and nonprofit regulation. The list could go on and on and on. And basically anytime anyone in Nebraska is hurt in the market, we have the potential to do something about it. I did that for companies. Now I just do it for the amazing people of Nebraska. And it's been the best career risk I've ever taken. And I think that there's other people here who have had similar experiences. I hear Tallahassee's nice.
To be fair, the Governor's General Counsel, Ryan Newman, when I first called him after he moved there, he said, "This is the greatest place to live in America. I am so happy, and I get to drive a truck." So I just want to note that with all the fun making of Tallahassee here, many people seem to like it. Okay, so one thing that I would just advocate to everybody out there before I get into questions is you should always ask the details of somebody up here. I only got to the Arizona Attorney General's office because I talked to somebody who said, "Would you ever want to work here?" And the appropriate answer probably from me would have been like, "No, because I can't work for $50,000 a year," because the Massachusetts Attorney General's office, that's what they would pay. But instead I said, "Well, I would love to, but here's the hurdle that I foresee, which is that I am not made of money, and $50,000 is not enough money to live as a young married couple." And their response was, oh, we can pay far more than that, right? So just ask these questions, because you have the details matter, and if you don't ask them, then you might not figure out that something that you thought was a pipe dream is available. So that's some of what I heard here, and I want to encourage everyone on that. Okay, so I'm going to try to split these questions up because you guys have similar backgrounds in that every single one of you has touched a large law firm, and many of you have touched clerkships, but wildly different in a very short period of time. So Jason and BB, in whatever order you would like, there's a lot of research out there that addresses the bias or the perceived bias in big law. Professor Derek Muller, who is bouncing around here somewhere, has done a lot of that work looking at the pro bono practices of large law firms, looking at the political donations of large law firms. He's come up with actual really good research on this. I commend everyone to go and read it. From your vantage point, you both were in large law firms, I'd say a little bit longer than some of your panelist members up here. Is the perception over or understating the current landscape of big law in terms of its welcoming nature to conservatives?
At least from my experience, I think that there's an argument about what is neutral, and they don't get what neutral means. So when I left, they would have said, this is a neutral pro bono program, but you can only do asylum work, really, and no religious liberties work. And that's the case with pro bono operations in most law firms. To me, that's not neutral, but they felt differently. So I think there is a large amount of unbalance, and it compounds over time. And one of the problems are that big law firms are in big coastal cities for the most part, and the pipeline, it just compounds the same type of people who hire people they like, who think like them, and there isn't an effort to reach out and find libertarians, conservatives, Christians who can sort of bring those perspectives into the firm, and so you kind of feel a little lost and by yourself.
Jason?
Yeah, I'll just add to that. I've seen some of Professor Muller's statistics on that, and it is pretty stark. For example, they looked at the political donations for the AmLaw 100. 100 out of 100 donated majority to Democrats, and if you donated 9% to Republicans, you would be over half in terms of diversity. And so it is skewed aggressively left. I think what a lot of the lawyers in this room will tend to look for is what I call like the conservative pocket within a larger law firm. And you can find in certain places with certain partners who have enough clout, like the ability to carve out these like very niche practice groups. And so I was able to work on some conservative pro bono cases, some conservative billable cases, but there's just that inevitable pull leftward that I think is inevitable.
And I want to note that part of the reason I asked that is because Gibson Dunn is a firm that is normally in the top quarter or better on all of this, so that's about as good as you're going to get. And over time, what that means to be in the top quarter has shifted, so at least according to Professor Muller. Okay, Lou and Amanda, for distinct reasons, when you're thinking of strategic litigation and the tools at your disposal, what are the biggest motivators you see within the shop that you work in terms of how cases are prioritized and selected? Right, because I think you're in very different positions on this, but I think this is one of the key aspects of the litigation ecosystem is case selection is everything. And your resources are very limited, no matter how big your office is. Jason's office is huge. And one of the chairmen of the Federalist Society is apt to frequently say that we have to get 7-to-1 on our resource front if we're going to get even with the other side in terms of dollars and resources and time and treasure and money. So how do you guys go about that within your shop? Whichever of you would like to go first, but I'd like to hear both of you talk about that.
So, from the Solicitor General perspective, you sort of sit at the crossroads between law and politics. And so the first factor that we consider in picking cases, what are the needs of our principal? In my case, that's Attorney General Catherine Hanaway, and frankly, I'm very lucky to have her as my boss. She's super smart, and we see eye to eye on a lot of issues, but it's my job as Solicitor General to think carefully. What are her priorities? What is she interested in? For her, for example, she cares a lot about public safety and getting drugs off the street in Missouri. And so you're going to see us do a bunch of innovative stuff on that front in the coming months. After I think about what she's interested, I get to think about what I'm interested in. And my personal interests really focus on election integrity and DEI. And so, again, expect a bunch of lawsuits on that front in the coming months. Beyond personal interests, we think carefully about what's going to make a difference and move the ball for real people in Missouri. So going back to the drug example, in St. Louis, which it's a city that's had some rough times in recent years, the most commonly used drug on the street by the homeless is kratom. I don't know how many of you have heard of that. It is actually legal in a lot of states. Some states have banned it. The federal government has not as of yet, but it is a quasi-opioid, and it is a scourge. And I think it is the next big drug problem in this country. And so in the coming months, we will take a series of aggressive actions to try to get kratom off our streets in Missouri. Next, we have to consider bandwidth and resources. Again, I'm lucky to be able to work for Catherine Hanaway. She gave me the resources that I need to build a big team. In just a few months, we've gone from 5 lawyers to 15. And you can do a lot of damage with 15 lawyers. That makes us one of the larger offices in the country, and I got to use those lawyers. So my people know that we work tough hours, we work hard, but we're going to try to move the ball forward on a variety of fronts in the coming months. And one additional thought that I'll close with, to the conservative legal movement. We talk about the state SG story, and it's largely a celebratory narrative about how state SGs are this force for good and are the cutting edge. But there's room for improvement in this story. A lot of states do not invest adequate resources in their state SG and special litigation offices. I have a lot of colleagues that do a lot with a very little, but really, $1 million invested by the legislature, toward the SG team, towards the special litigation unit, you can do a lot with that. And you can bring real returns to the people of the states. And so to people that influence state governments, to donors who are thinking about what to push people to do in state governments, this is something the conservative legal movement can be better on. We should try to make sure that these offices have the resources they need to hire more than 2 or 3 people, which unfortunately is still the case in a lot of states.
Lou's going to be too shy to say this. At least when I was the Solicitor General, and I'm looking at somebody in the room who once told me this fact, there were state SGs in the country that were making 5-digit salaries while being the state Solicitor General. And that is not very much money, no matter where you live in America. And the entire budget for the Federalism Unit in the Arizona Attorney General's office on a yearly basis when I first arrived, and this was a really big deal that we had, it was $1 million. Now, $1 million before President Biden was president, it's a lot more money than it is today. But Lou is entirely right about the scale and scope here and about the level of resources. Okay, so for BB and Cody, in whichever sequence, what's the best use for your category of entity within the strategic litigation landscape? And here, BB, I really want you to talk about what you actually do, not what Mike does broadly in the entire office. Nonprofits, governments, size of law firms, there is a real use case, and I hope to think that you guys think about what your highest and best use is within the ecosystem. I know that you do. So can you talk about that in terms of, what is the actual best use of Constable McCarthy? What is the actual best use of a consumer protection division within a state?
I'll give a quick answer and then let Bibi talk more. I think there's two answers. One is Convoy specifically, and then one is just boutique firms at large. Like a lot of boutique firms, Convoy is, in a certain respect, a full practice shop. I mean, we can do everything. We can represent you in administrative proceedings or in notice and comment. We certainly do trials. We certainly appear in state courts. But the real thing that Convoy is built around is largely Supreme Court level advocacy, or at least being in lower courts in litigation that has a good chance of going to the Supreme Court, and so is done with that strategic thing in mind. So that's the best thing for I think, Convoy specifically, and that's why we're brought in by other states sometimes or by nonprofits for that specific purpose, even though we do many, many other things. For boutiques writ large, I think the competitive advantage for boutiques is that whereas Amanda was talking about nonprofits get to specialize in topics, boutiques get to specialize in areas. So just as Convoy is specializing in largely appellate or appellate related, other boutiques can do other things. So I mean, Boyd & Gray is a wonderful, wonderful firm. And they are able to do everything. But they do much more administrative things before litigation than we do, and they're fantastic at it. And you can have other firms that specialize specifically in state courts in one state, and they're going to get a competitive advantage in those states. You can have boutiques that specialize in federal trial courts, and if you build the right team, you're going to have a competitive advantage there. And I think there's a real opportunity where more and more of these start to pop up, because you can basically break apart every practice area that a big law has. That can become its own kind of area where a boutique firm has a competitive advantage.
I think having done consumer work in big law, where you have all the resources and none of the power, I've sort of flipped it. So I have none of the resources and all of the power. And that's where we can come in and we can investigate. We have a ton of claims we can bring, a ton of angles. We get to represent the whole state of Nebraska, including small businesses. We have just a huge tool. But without the ecosystem, we would not be able to do it with just 6 attorneys. So when a matter comes in, we have to think about, should we handle it? Does this give Nebraskan taxpayers a return on their investment? Are we the only shop that can do it? That's often the case for small dollar actions. We got 3,000, I think, small businesses, $100 back. No one's going to sue over that, but we stood on principle. Things like that. When they come in and that's my job actually, is they come in and I try to figure out, how do we do this? Often I'm talking to these guys. I'm talking to other states who has time to draft a CID for everyone. Who should we hire to do this? Who would do this on contingency and be good? Who's already working on this? And it's been really fun. Nebraska files a lot of lawsuits. And part of that is because we're building this ecosystem, and we can work with our friends and really give value back to taxpayers who rely on the power we have, and we just find friends with resources.
Okay, so Cody and Amanda for this one. Can you talk about how you collaborate with the rest of the strategic litigation community in your present role? And can you, discuss how much you feel siloed from the rest of the strategic litigation community, and how much you feel like you're serving an important part in a different machine when your outfit is a different cog in a bigger machine? Because I think it is not always obvious from the outside what it feels like on the inside, and how that feels in terms of the trying to maximize the resources side of what Bibi was just describing.
Yeah, so I'll address that, and then along with kind of how Beckett chooses which cases to get involved with. So part of that, I can speak somewhat to nonprofits generally, but I would say part of my answer is Beckett specific, and then also how we work with, our affiliates, that's also a little bit Beckett specific as well. So we're a relatively small shop. At any given time, it's usually between 25 and 30 attorneys, and we would love to take, every religious liberty case that comes in front of us, but we're not able to do that. So we're trying to find the cases that are going to have not just an amazing impact for the client that we're litigating on behalf of, like that is obviously a key component, but we want to take cases that will impact religious liberty for all, that will advance that mission. And so, we're really grateful to have the opportunity to be very involved in the cases that we take. We are, we are actually litigating all of our cases, but we do get to work with governments and with other firms as co-counsel, like in amicus relationships, and that's a huge part of what we do as well. I think it's very collaborative on our end. So, for example, one of our key cases, Frankel, we're litigating on, against UCLA, and we had Clement Murphy there with us from the beginning, and then Davis Polk came in and we're helping out with discovery. And that was like such a key partnership in a very big case, and we couldn't have done it without them. At the same time, right now, we're litigating a case before the en banc Fifth Circuit. We're co-counsel with Louisiana, and I'm getting to litigate with another friend, which is fun. And so I really think that's an asset and something that I've really enjoyed having, again, the expertise of Beckett, but then being able to work with other outfits that have different skills, different resources, and sometimes even different goals that's going to help contribute like to our mission, but also have maybe a broader impact as well.
Yeah, and then just on collaboration, I think my opening remarks probably covered a lot of this, but a massive amount that Consovoy does is purely built on collaboration between states that hire us, nonprofits that hire us, and other things like that. As to what that actually looks like, it really just depends both on the particular client and sometimes the particular matter, how much time they have to devote to that particular case. Without naming names between the states or the nonprofits, sometimes we're handed a case, and due to time constraints by that state or nonprofit, it's basically just like, here's what we need out of this. You have full control over the brief. And sometimes it's a lot more back and forth. We'll put together the bones, we'll get feedback. It could be, any variety of these, but it's very, very collaborative. And that often extends, due to the nature of our work and the cause-based litigation that we do, that does also include not only the direct representation, but the use of, tapping into the network, the friends that we have around the country, the similar shops around the country, and using that as, amici and support. So just about 2 months ago, we had a case that was being argued in the Fourth Circuit on a free speech discrimination or retaliation sort of thing that arose in Loudoun County School. It's a whole issue there. And for that, we had been brought in by a nonprofit, American First Legal. They wanted to do that case. They brought us in. So we've got the nonprofit, we've got Consovoy, and then we ended up getting the Solicitor General of Virginia to come in and argue as well on the amici. So you had Consovoy, you had the SG, you had the nonprofits all working together on the same case. And I think that sort of thing tends to happen pretty regularly.
So this one's for Lou and Jason for obvious reasons. When you look at the bench, and you see how many of the Trump appointees on the bench worked for state AGs. Maybe they worked for a law firm like Consovoy, but in particular state AGs. Do you think that you are more likely to speak the language of the younger judges, even if they are not really that close to your age, vis-a-vis big law firms that you're litigating against? Like when you go into an argument, an appellate argument, any of these things, and you think you are just in a fundamentally better position because of your job experience and the match to that. The joke amongst the first slate of judges was in the most recent beginning of this process was that the best way to become nominated to be a judge was to be somebody who worked for Senator Eric Schmidt or Josh Hawley when they were Attorney General, right? Or do you think that whatever you're getting in terms of an edge is just because you are conservative and more of the judges are conservative, or does the role matter?
I think that, so the answer to your question is yes, and I think this is the basic reason why. I talked earlier about the importance of keeping your thumb on the pulse of current intellectual trends among the conservative legal movement, I think a lot of partners at big law firms just don't do that. And frankly, their thinking is kind of outmoded and stuck behind the times, and they don't see trends where they're going. But judges who have served in government positions, and especially in state SG positions, they had to spend a significant amount of time in their career thinking about the direction of law, taking initiative, going on offense. And so in that respect, I think, yes, state SGs do have a competitive advantage because it's a similar mode of thinking. The other thing that I'll say, though, just as sort of food for thought for the future, FedSoc has had 10,000 events about the importance of textualism and originalism. And these are great events. It's very important. But one of the big questions in the coming years is not just going to be, do judges take a textualist or originalist approach to a particular question? It's going to be, how do judges develop and shape doctrine to implement an originalist and textualist approach? And this is something I'd like to see the Federalist Society and people within the movement do more thinking about. I remember, I was clerking at the U.S. Supreme Court when Bruin was decided, and there were a lot of articles about the importance of originalism in the Second Amendment context. Not a lot of writing about what Second Amendment doctrine should look like. How should the sensitive places doctrine evolve, for example, when you're thinking about where you have a right to carry a firearm? This is a question that I'm litigating right now in the Missouri SG's office. A lot of conservative, right-of-center scholars and even practitioners are still not thinking critically about these forward-looking questions. How are legal doctrines going to evolve? Just because legal texts do not change, that's originalism and that's textualism, does not mean that legal doctrine does not evolve, because it does, and we need to do more critical thinking on how that happens.
As the old person in the room, I will just flag that Lou is identifying something that is, I'm sure there's a sociological phrase for this. The wins that have occurred in the last 6 years, for those of us who are a little bit older than Lou, they feel like wall after wall fell that was requiring immense levels of effort to try to topple. And once one of them fell, the next one fell, the next one fell, the next one fell. And so now I think Lou is looking at a universe with fewer walls and thinking, why don't you think about what was behind it? And a lot of people were thinking, can you believe we finally knocked it down? And so I would just say that one of the exciting things about this Federalist Society convention with the New Frontiers, and a lot of what is discussed amongst the leadership of the Federalist Society is filling in the things that have occurred now that there's been a breach in the other side's defenses. The generational wins that have stacked up are something that is truly beautiful to behold, and something that I can tell you from when I was in law school. Each one of these felt like something that if we had accomplished it alone in a 5-year span would have been something to hang our hat on as a movement. So this is a function of the success, and it's very important, and it is very front of mind to people, but it still must be done. Jason, your views of this kind of question of being state SG, does it make you better at winning against a law firm of, non-thinking people?
Yeah,
that's what you said, right?
That's definitely not what I said.
Okay.
I agree with everything you guys said, so I'll just add quickly. I also think it's issue specific to some regard. Like, I have spent more time on preemption battles, and like that I hadn't even thought about much. Certainly in big law, and honestly, I don't even know that I spent a ton of time thinking about it in law school. But so you imagine, like, all of the Florida state laws always get challenged on some preemption. Some federal statute happens to have some similar topic, therefore preemption. But like, state SGs are litigating that every day. And so that's just an inescapable like career experience now that we have more people on the bench that we think, because we've lived in it day in, day out, that they're also more attuned to some of those concerns, some of those dynamics.
Yeah, I will say that non-ideological things end up being hugely valuable in how we litigate important cases. I would say that the amount of people in big law who've never read a consumer protection statute and don't realize that there's in some states for the state no statute of limitations, only for private, and they'll write you a letter saying, that's the statute of limitations. And then you'd write back and say, you didn't read subpart 2, your associate should be, fed into whatever pain machine you have for them. And similarly, you would see people who don't understand that states aren't removable, right? These like very simple, very important questions that are massively overlooked in law firms because they're not repeat things. So we have enough time that I would love each of your thoughts on this. I think this is, try to be as introspective as you can. If big law is trending back toward neutral, So something my good friend James Burnham and I talk about from his time working at the White House. A lot of belief that whatever the tactics, that the president accomplished something where law firms are now making a concerted effort in the MLaw 100 to at least appear to be neutral. I take BB's point, they don't know what neutral is, but they're working very hard at it in their own minds, and the administration thinks that they are too. If big law is trending back toward neutral on a multi-year time horizon, does that change your future job goals? But I mean this from the perspective of, is the conservative, strategic litigation ecosystem something that you relish because of the problems in big law? Is it something where if big law could get back to neutral and more big law firms looked like the Gibson Dunn of what people remember from the 90s, does that change it? Or do you think that the ecosystem has reached escape velocity and that no matter what happens in big law, none of you intend to really want to go back and you don't ever feel the need to go back because we've become self-sustaining? I would just like each of your thoughts on that. I think we have time for that, obviously just a couple minutes, but I think this is the most important question.
I mean, the way that I think about it is, am I able to have agency in what I do? And am I able to actually litigate the cases that I want to litigate? And I think the fundamental challenge with big law, and there are some exceptions, like my own experience at Jones Day, is that the business model depends on leveraging associates and younger lawyers as cogs in the machine. And so even if big law firms were not so biased towards the left, I think that there will still be a need and a demand for these new types of litigation options, because if you're a young lawyer and you want to become a real lawyer, you got to take one of these jobs. You can't just be in a cog in a machine at a big firm, and so you can't go back.
So I want to ask one clarifying question though. Imagine a universe where you are in 5 years leaving, and a big law firm offers you to be a partner at the firm where now you have agency, you have case selection for you, right? Does that make the strategic litigation ecosystem a young person's game only in that future, that imaginary future where big law is tacked back to the middle? Or does it still hold, does it still have a grasp, does it still have some ground to hold amongst people as they advance up into the middle part of their careers?
I think it depends. I mean, for me, I could never just have a diet of litigating corporate cases where one corporation hands $1 million to another.
That is a very good analogy.
I was primarily an election lawyer at Jones Day. I woke up feeling good about what I was doing. If I could do that again, I'd certainly consider going back. But I think that's an unusual circumstance, and I think we need these other types of litigation options for people earlier in their career, middle of career, and later in their career.
Cody?
Yeah,
I'm not asking whether you want to leave the firm, and I'm not going to tell anybody your worst situation.
to any partners watching.
Imagine
I'm very
a
thankful
universe
for my
that's
job.
like 10 years away and all of them are retired or whatever. Just something like that.
So the short answer is no, but let me jump back to the overall bias question, just because I want to raise something that I've learned very recently that I think is kind of concerning. I'm not one to comment on any perception of bias in big law because my stint was a summer during COVID, which was not much of an experience with big law. I've not otherwise practiced there. I do think there's a growing concern that has not been addressed in the literature or the commentary, which is to say, when I was coming off of the DC circuit, where I clerked for an absolutely phenomenal judge, Justin Walker, all of my co-clerks and I Consovoy was my first choice, but we all applied to a lot of firms. As far as I know, none of us received a single offer to interview with a big law firm. And at first I thought that was just us, but in just the recent weeks, I'm starting to hear more and more accounts of, while these firms are saying that they are welcome, and I do know that they're hiring some conservative lawyers coming off of good clerkships, there is a disturbing number of incredibly talented, credentialed people who are coming off of clerkships with judges appointed by President Trump, who simply are not receiving anything back from big law firms. So that's a concerning thing, I think, looking forward, that while they're trying to purport to be moving back to neutral, they're simply blocking off the access point. But that's not the hypothetical, so I'll jump back. Even if you assume a world where it does go back
I'll just note as a person who graduated in a slightly different economy, the economy had something to do with that. We'll see.
It might. But they were hiring other people. if you assume that it goes back to purely neutral, I think my answer is still no for very similar reasons. I also agree. I'm just not really that interested in a corporation giving the corporation another $1 million. Jason, your line is fantastic. And the other thing is actually very similar to what Lou said about autonomy. I think, there is great value and pride in the sense of accomplishment of doing meaningful work whenever you write a brief and that's your brief. Or at least you're on a small team, a leanly staffed team, where two or three of you get together and you plan out that case and you litigate that case. And my understanding is that's not really how it tends to happen at big law, even if you start to get into the higher levels of position in choosing your cases. And even if you are choose your cases, I agree with Lou. My understanding of the business model is that in order to keep that large of a corporate structure afloat, you can't really take cases that might appear to shake the boat. And so at best, it seems like the best you will ever be is neutral. And I have a lot more fun doing what I'm doing right now.
Yeah, the answer is no, because I have no interest in being neutral. So that's just not enough. But I'll just, maybe I'm more pessimistic than you, OH, but I love what the Trump administration has done. I love what a lot of the states have done to try to change.
It's a hypothetical.
Hypothetically, I love what's been happening to try to structurally change the law firm incentives. I just think it's, right now, law firms biding their time. In the next Democrat administration, I have a hard time believing they wouldn't do anything but come roaring back to everything they were doing in 2021. And so it's almost a moot point, but who's there, who's going to be there, who are in their pipelines, who they prioritize. I just don't see it happening. And so, yeah, it's almost easier just to accept that and to say, I don't want to go back. I don't know if I'd be accepted back at this point. So let's go forge new frontiers.
So sticking with the trend, my short answer is also no. But for me, again, I think I actually had a pretty positive big law experience. I didn't feel like I was running away from the firm. It was just, can't pass up the job that you've been your dream job for years, and that kind of is the end of the story for me. But I will say that I would love to see this shift because I do think that it's something that would make big law, and especially the revolving door between big law and government, it would make it a lot easier for people to be able to go in and out. I don't know how the firms would feel about that, but I personally just don't really see a need for the firms to be taking any ideological stances on the vast majority of issues, and I just think that being neutral, to me, I just think it would actually be better for everyone. And it would also allow people who want to be in private practice to do work that is meaningful to them, to spend their pro bono hours well, but also to be able to stay in firms if that's what's best for themselves and their families.
Yeah, I don't see the benefit of going back for what I like doing. I think that we're maybe all millennials and we're supposed to care more about purpose than money, and I definitely feel that. And big law is where you go to make money and work on cool cases, but I don't see the benefit of that system, especially when there are so many other options where you can essentially have the same thing, but with people you really like.
Okay, so I was pretty sure I knew the answer to all of this, just so you all knew, because I know many of the people up here. But I would note that this is the most important thing from the whole episode, which is what BB just said, which is that there's options. Because I actually think that there was a large cohort of people of the same age 10 years ago who could be sitting at a Federalist Society event and would have said, that's what I want to do, but that would require me to be in the top 3% of the conservatives who happen to also want to do that, and then I might get lucky enough, right? And it's only now that you have a fully built out new strategic litigation ecosystem that if you actually want to do it, there's not 2 SG's offices in the country that are doing this. It's not just, Jeff Sutton in Ohio and one other place. It's a wall of them. And Lou is describing how if they could get an extra $1 million here and an extra $1 million there, that'd be really good. And you have multiple firms, new firms, old firms that are growing, outfits like Beckett, places like ADF that are just scaling and scaling and scaling. So I think that is a testament because every single person here is in the ecosystem and realistically would love to welcome in a whole nother cohort of people and then say, yeah, you never have to go back. So with that, I'm supposed to read something. I'm really good at stuff like this. One brief announcement on CLE. Since this is the last CLE panel of the day, please be sure to check out by scanning the QR code you scanned when you checked in. You are now heading into a networking break before the Olson Lecture, which will start in the International Ballroom Center starting at 5 o'clock. Thanks all, and we're adjourned.